And if you look at the bottom of that page, that is dated with the stamp date 2025-07 July 14. So this is the notice of alleged misconduct in terms of 8.1, and then look at what happens immediately on that same day. Turn over the page to SS2 at page 001-59. And it says, following the media briefing, and I'm reading from paragraph 2, following the media briefing from the Provincial Commissioner KwaZulu-Natal on 6 July, this office is gravely alarmed by the allegations leveled against yourself and the subsequent commission inquiry established by the President. Given the seriousness of the allegations, you are hereby instructed to stay at home pending the outcome of an investigation. So the relationship, it seems like, between these two things is the 8.1 notice says here's the notice of alleged misconduct, and this thing that comes at SS2 is saying you must stay at home. Now, before I examine this against the regulation, Justice Davis, may I just point something out insofar as what comes out in the answering affidavit? Remember, I think you said to me it was 8.26 in the answering affidavit where the National Commissioner's justification was you're going to interfere, I need to protect the integrity of this process and so on. Now remember, the suspension notice, the second suspension notice that we were talking about earlier comes after the answering affidavit, okay? So before the answering affidavit was filed, the only documents that gave effect to keeping General Sibiya at home were these two documents. And the problem for the answering affidavit to disclose those reasons, I've asked you to stay at home or whatever the case is because you're going to threaten the investigation, your presence is going to intimidate someone, is that that doesn't feature anywhere in SS1 or SS2. And yes, it does, because what you know from Long versus SA Breweries, and let's maybe go there together, I think it's paragraph 25 of Long versus SA Breweries. Both my learned friend and I rely on that authority. If you'll bear with me for 1 second. Do you have Long? Here we are. I apologize, I found it. Thank you, I'm indebted. Anyway, the point is that what was established in Long is that the suspension must serve to protect the integrity of the investigation or process or mitigate risks to the employer whilst such an investigation or process is ongoing. That's what the High Court said, and you know that the Constitutional Court didn't interfere with the High Court's decision. Now, why that's relevant, Justice Davis, is that...
Was that the High Court or the Labour Court?
I apologize, the Labour Court, and that was not interfered with by the Constitutional Court. Justice Moshuwana is entirely correct. But Justice Davis, going back to the engagement we were having, the reason that's relevant is because you also know from public law principles that when a decision maker takes a decision, their reasons are corroborated by the contemporaneous evidence at the time. It's insufficient for them to advance reasons in the answering affidavit where they don't appear in the original document that captures the reasons for acting. So why, with all due respect, I say that the absence of those reasons in SS1 and SS2 is relevant is because you can't claim in the answering affidavit, I'm protecting an investigation, when at the time you're communicating, stay at home, you don't say, the reason I'm telling you to stay at home is because I'm protecting an investigation. So that disconnect, both factually and legally, thank you. No, it doesn't. and it doesn't for the reason that Justice Moshawana said in the Letswaolo matter. When you're in VRAs in the disciplinary regulations, then it's not administrative action, that's a fair labor practice question. But if you're in an ultra VRAs scenario, that's when it's administrative action. And the point that we have been making is that because there's no authority for the stay-at-home decision, we're in the ultra VRAs admin action ground and not in the intra VRAs fair labor practices ground. So it doesn't have the effect of elevating every decision to administrative action. It's only those targeted ones which fall outside the enabling instrument. So,
Sorry, Councillor, I think what I understand my brother can ask you is the National Commission says in the answering affidavit, I did not exercise powers emanating from the regulator. I is applicant on a precautionary.
yes,
And in order to establish whether that is possibly correct, if you look at SS2,
yes,
nowhere is there reference to precautionary suspension. Nowhere is there reference
Yes.
to the clause that
Yes.
deals with precautionary suspension.
that's exactly the point.
But what is apparent from these notices is that, 3, given the seriousness of the said allegation, you are hereby instructed
Yes,
to stay at home.
Yes.
Pending the outcome of
yes. And the reason for the stay-at-home instruction explicitly is because of the media briefing from the Provincial Commissioner of KwaZulu-Natal and the allegations that he stated. So it's not a stay-at-home order given in the ether, it's a stay-at-home order given specifically in response to those allegations. And that brings us back to the central question of, do you have the power to instruct to stay at home, where the purpose of your stay-at-home instruction, and let's adopt what they say in the answering affidavit, for the sake of argument at least, is to preserve some or other instruction. Now, if that is the case, then your stay-at-home order, in effect, is actually a precautionary suspension, because remember, that's what the answering affidavit tells you. It's telling you stay at home so I can protect an investigation. Or, if it's not a precautionary suspension and it's just a stay-at-home order on its own, then it's still unlawful because there's no authority for such an order in the disciplinary regulation. That's the point, with all due respect.
But why do you want to go to the disciplinary regulations when the repository of power, we don't know where, for a moment let's assume that he has no powers at all. He has no power, but he did something.
Yes.
He did something by instructing the applicant to stay at home. Now, why do you want to then persist and say that that which he did can only emanate from the disciplinary regulations and not, for instance, from the Constitution?
My Lord, I've answered that question, and that's subsidiarity, with all due respect. If you look at 001-87, which is the regulation, you will see that under paragraph C, the definition of employee means any person employed by the SAPS, excluding the National Commissioner and the Provincial Commissioner, so that's Lieutenant General Sibiya, because he is a deputy national commissioner. And then it goes on to, and this takes us back to the point that we discussed earlier about Regulation 2 and the scope of the regulations. And so the point is that the regulations are the instrument which manage discipline in the SAPS. And I see Justice Moshawana shrugs at me. The point is, with all due respect, is that if the Constitutional Court's authority tells you that when a subsequent piece of legislation, either a principal piece of legislation in the form of an act, or a policy, or a set of regulations, is the direct regulatory instrument of a topic on the same subject matter, you are not allowed to look behind it because the principle of subsidiarity stands in your way. So it means that for any decision that has a disciplinary consequence, it is only the disciplinary regulations that apply. And so if the National Commissioner's case, as it is that I didn't act in terms of the disciplinary regulations. I acted directly in terms of the Constitution. One, he concedes then that he's breached the principle of subsidiarity. But two, more than that, it illustrates that he acted without authority, because he did something that the enabling instrument didn't allow him to do, and that, with all due respect, takes us back to paragraph 16 of Letswaolo and the RAF matter. You can't do it, it's a nullity, and therefore it can have no consequence or purchase in the context of what happens with the general. But let's go back to SS1 and SS2 in the way that we were discussing them, because what you will see is that, and now I'm looking at 001-96, as the court pleases.